prior, you can argue in rebuttal if you'd like.
Judge, I had represented that we would be prepared for a trial in October, and I had made that representation to the court when we initially set the first court date. I was basing that on the assumption, the incorrect assumption, that I would have the entire discovery in this case. That has not been the case. In fact, since that time, there's been a significant amount of discovery since that original trial date to the present. I then made the representation that I could be ready for trial in January. I then discovered, Judge, that the prosecuting attorney conducted a grand jury investigation into some witnesses in this case, and this judge ordered a transcript of that proceeding. Now, I was lucky enough to discover the fact that witnesses in Chad Daybell's case were called to testify in front of a grand jury. Okay. I'm not allowed to go into the facts of that, but they clearly were, because this court entered an order just a short time ago and provided me with that transcript less than, I think, a week ago. And I've had an opportunity to go through that. Now, if I did not have that evidence of those witnesses being testifying in front of the grand jury and all of the other evidence, Judge, I would have been prepared to go to trial if I didn't have that evidence and it didn't exist. And I would have been ready to go to trial in January of 2023. And I have made that representation based on the current status of what I believed I had in terms of the evidence. Now, we are here on the 19th of January of 2023. Again, in August, there was an order that I be provided some DNA evidence. I do not have that evidence. And I could really care less whether the state thinks it's exculpatory or not. It doesn't matter what they think, and I could care less what they think. But I'm concerned about what I think. And if I think that evidence is exculpatory, I'm entitled to it. And I'm entitled not only to have that evidence, I'm entitled to test that evidence and have an adequate amount of time to do so. And they don't get to dictate and one-sided, and we've been through this before, and I didn't want to turn into this kind of a tone, Judge, but we've been down this road before. They don't get to dictate what's exculpatory and what I want to use in my case. The only thing they're entitled to is I'm going to show them what evidence I'm going to use. That's what they're entitled to. And they're going to get that. But until they get those reports and the expert reports that I have to prepare, I want the evidence. I want the evidence. I want my expert to have an adequate amount of time to test it. And Ms. Blake brought this up. In both of those DNA cases, Judge, I entered into a stipulation that allowed their expert to test the evidence, give me the report, and allow me to follow up and do further testing if I deem it necessary. And I accommodated them to allow them to do that. And to suggest that I can at any time go do that, that would be in violation of the stipulation in the order that was signed by this court, and the most recent one. So I don't have DNA evidence from August of last year, and I'm waiting on the report, and there's no date as to when I'm going to get that report. And you're going to hold me to a deadline to disclose an expert opinion. And I don't know whether it's exculpatory. I have an opinion, and I want the evidence, and that should tell something to the court. I want the evidence. And now we have new evidence that was disclosed approximately 20 days ago, 3 weeks ago. And we entered into, again, a stipulation in an order that allows them to test it, and on their schedule, get me the report so that I can follow up and do my own testing, and then get a report. And I don't care what they say. I'm entitled to all evidence and make my own adequate determination as to whether it's exculpatory or not. And they can't tell me when I'm going to get the evidence. And I'm not going to sit here and say, well, you got me the evidence and you decided that it wasn't important enough. That's not the way this works. I want the evidence. I want time to be able to test it. I want time to be able to issue a report. And I want time to be able to prepare for trial. And you're asking me to do that in the next 9.5 weeks, and they haven't even got me the evidence yet. And I disagree wholeheartedly with Ms. Blake. Quite frankly, you don't get me the evidence, and I don't do an adequate job, and I have to hold myself up to a standard of an attorney defending someone in a death penalty case. Are you kidding me? You don't think a court's going to turn this over? They're going to snap and do it in a minute.
Your Honor, if we could just briefly. I think there was a lot of misrepresentation in there, in addition to the fact that towards the end, counsel was addressing me directly rather than the court in his argument.
Understood. In lieu of a sidebar, I don't think that's necessary. I'm ready to make a ruling on where we stand right now based on proceedings before the court. The court has before it the motion to continue filed by Mr. Daybell in the 1623 case, and I've considered the pleadings as well as the arguments here today. The court, I'll go through some of the standards I have to look at here. Under the State versus Griffith case, 144 Idaho 356, denying or granting a motion for continuance is reviewed under an abuse of discretion standard. And the question is, to warrant a reversal, does a defendant show prejudice for the denial of a request for continuance? That also cites case State versus Nunez, 133 Idaho 21. More authority on that, the decision to grant a continuance rests within the discretion of the trial judge. State versus Ward, 98 Idaho 571. That case also talks about a showing of prejudice, whether or not there is. And citing State versus Laws, 94 Idaho 200, unless an appellant shows that his substantial rights have been prejudiced by reason of a denial of his motion for continuance, appellate courts can only conclude there was no abuse of discretion. One final cite here, State versus Richardson, 95 Idaho 446. There are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly the reasons presented to the trial judge at the time the request is denied. So I've considered those factors. This is obviously a complicated case. We've got two separate cases. Both the defendants are here today. They are joined for trial. And there's been multiple requests to sever these cases because they've been charged together as co-defendants in conspiracy charges. The court has denied any attempts to sever up until this point. So right now we've got trials scheduled to start in April of 2023. Mr. Pryor's been representing Mr. Daybell since June 12th of 2020. This trial in this case was scheduled originally for November 8th, 2021. It was scheduled again because of delays which were outside the control of everyone relating to competency issues. And we set the trial out substantially to January 9th of 2023, which would have been in trial now had that date held. After the competency issues were resolved, we again had a scheduling conference. It took a lot of time and consideration, and we scheduled trial for April of 2023. On the one hand, the court has considered the arguments set forth in the motion to continue that relate to the time necessary basically for preparation, mitigation, the other rationale cited in the motion to continue, including ongoing investigation. And I've also considered the arguments today that it appears there may still be outstanding evidence being developed in the case. The overarching concern this court has is the fact that although one defendant, Mr. Daybell, is requesting to have this trial set out yet another further year out, the co-defendant, Mrs. Vallow Daybell, in her case, has unequivocally asserted her right to a speedy trial, has never equivocated at all on wanting things to go without delay, hasn't waived anything there. And I say that's overarching for me because that's an express constitutional right that she maintains. And the factors I've previously considered in these continuances, when I've looked at the right she has to speedy trial and balancing that out to the rights Mr. Daybell has in the case, I'd be very, very concerned if I were to set a trial out for her another year from April. At that point, I think, in my opinion, I've probably gone too far and violated her right to a speedy trial by making her wait too long. One of the very significant factors you consider in that is whether or not, or is the length of the delay. So that puts everyone in the situation. Mr. Pryor, you've got a client that's joined together with another defendant who refuses to waive a speedy trial. Your client has waived speedy trial, so that issue doesn't present for him. Because the cases are joined for trial, that drives the court's decision here, because although it's concerning that there still needs apparently to be additional evidence developed, I can't, with these cases joined for trial at this point, push the trial out any further than it's already been pushed to April 2023. And so the trial is going to go forward in April of 2023. On this issue of the question of whether or not there's potentially exculpatory evidence, there's a procedure in the criminal rules. If evidence isn't being disclosed in time through motions to compel, those haven't been filed with the court, but I think Mr. Pryor certainly has good cause to raise those objections at this point. Mr. Pryor, you've raised the concerns about the deadlines of disclosures required in the court's scheduling order. Clearly, those can be modified for good cause, and what you've argued today may well constitute good cause. So the determination I'm going to make is I'm denying the motion to continue the trial. However, that is really mostly premised on the speedy trial right that's been asserted by Mrs. Vallow Daybell in the 1624 case. If we are still up on the eve of trial and the state has potentially exculpatory evidence which didn't provide an adequate time for Mr. Pryor to have that tested, or whether it's been confirmed whether or not it is exculpatory, or whether there is any evidence there, at that point, I'm just going to advise the state that may well result in the court, if Mr. Daybell still asserts the right to that evidence, the cases may need to be severed. Because I'm not going to force Mr. Daybell into a trial if potentially exculpatory evidence has not yet been tested. I think that then violates his right as well. The state has the right to try this as a single case, not severed. I've ruled on that previously. The state does not have a right to not have the evidence ready and sufficient that I end up potentially violating the due process rights of Mr. Daybell as well. So all I can say to the state is, you better tell the state lab that if you want to not have that possibility hanging over you as we're moving towards trial, I hope they can expedite the testing of this evidence. I don't know their procedures and how long things take, but it's the court's understanding, based on the charges in this case, that the crime scenes were secured. I think it's been close to 3 years ago, so I don't understand why, given the multiple delays we've already had here, these issues are still coming up at this time. But Mr. Pryor's correct that he gets the right to see that evidence. It could be exculpatory, and if it is, then he can't be required to go to trial without knowing that there isn't exculpatory evidence out there if it's been revealed. So I know that was a long way of saying I deny the motion, but I wanted everybody to be clear on the rationale. So I am going to still order that this case moves forward under the court's current scheduling order that we issued January 9th, 2023. To the extent any of the deadlines need to be modified, council's to make a motion to modify those, and if further concerns come up regarding this evidence, Mr. Pryor, I just instruct you to schedule that and have it heard for motion hearing, and we can do that on an expedited basis if necessary. So that'll be the court's order denying the motion to continue the trial. Any questions on my ruling, Mr. Pryor?
Judge, no questions. I want to make sure that the court's aware. I actually got the notification. There was a motion to sever that was filed in this case. For whatever technical reason, that wasn't, and part of it was my fault in the date that was placed on that. However, there is a motion that's now been filed to sever this case. It was previously, I think, back in December provided to the state. So there is a motion to sever, and I anticipate arguing that on the 9th of February, unless the court feels there should be a different date to address that issue.
All right, Mr. Pryor, if you'd like to argue it on the 9th of February, we've set that time aside, and we'll get the motion scheduled to be heard on that date for motion.
Thank you, Judge.
All right, does the state have any questions on the court's ruling denying the motion to continue?
No, Your Honor, and the state is going to do everything we can to expedite that testing.
Very well. Thank you for that comment, Ms. Blake. That'll conclude the motion as it relates to the trial continuance then. The next order we'll take up then is the state's motion for sequestration of the jury. That motion was filed actually in September of 2021, and the court issued an opinion and reserved partial ruling on that in an opinion from October of 2021. An objection to the motion for sequestration of the jury was filed by Mr. Daybell's counsel January 11th, and also on January 12th, Ms. Vallow Daybell's counsel filed an objection as well. So let's have that matter heard next. Who for the state's going to argue the motion?
I am, Your Honor.
All right, Ms. Smith, if you'd like to make your arguments this time, then you may.
Your Honor, the state will be brief. Both parties have submitted their motions, and the law on this is clear that it's within the court's discretion to do what the state asks. The primary reason the state is asking is we are very worried, given the nature of this case, given the publicity in this case, that if the court does not sequester the jury for the duration of the trial, that there will be problems because of the publicity with keeping the jury secure, keeping the jury independent, and making them have no contact from parties about this case. If the court looks at the experience in this case, at grand jury, in fact, there were citizen journalists around the courthouse taking pictures of our witnesses. One of our witnesses had their picture of their baby in the paper. The idea that some of the individuals associated with generating publicity on this case won't reach out to jurors, we just don't have confidence that that won't happen. We have real concerns that if the court doesn't take steps to keep the jurors isolated, that we'll be mistrying this case during the trial. If jurors have contact from third parties while the case is before the case is submitted to them, and then they consider outside factors, it violates both defendants' rights to fair trial. And the substance of our motion is based on asking you to use your discretion to protect both sides, both defendants and the state's rights to fair trial. We recognize it's a lot of money. We get it. We also recognize that it is a real challenge and hardship for individuals. But this case is a case involving the death of 2 children, involving the death of a mother of multiple children, and requesting that the death penalty against 2 individuals who right now the law presumes innocent. And so while we understand there's a hardship to the public, we understand there would be a hardship to the jury, the rights of both parties and the stakes for both parties justify such an action. We know it's in your discretion. We know they have to be sequestered once the penalty phase begins, but we're asking you to extend it to protect everybody's rights and to protect the rights of our witnesses, to not have information about them that the court has excluded given to jurors. There's the real potential that's going to happen. Other cases of high publicity, the Rittenhouse case, that case, a journalist followed the jury bus And fortunately, the police were able to keep them together and it was identified and brought to the court. You won't have any of those protections. The other piece is it will be very easy for people to find the jurors and reach out to them. In other high-profile cases, there were approaches to jurors saying, hey, keep notes and keep a journal so that you can write your own book. If there are no safeguards provided to these people, given the attention, given the activity of some of the citizen journalists on this case, we have real concerns about the integrity of the process. I'll stand on the law. The statute's clear. The case law's clear. This is within your discretion. We understand what we're asking of you. We're just saying the rights of everybody involved merit it.
Thank you for the argument. Ms. Smith, and for the record, that's Rachel Smith that provided argument on behalf of the state. All right, there were objections filed by both defendants in this case. Let's see who would argue in response. Mr. Archibald?
Yes, Your Honor.
Mr. Archibald, on behalf of your client, what's your response?
May I remain seated?
You may. Thank you.
Typically, I would agree with the state to sequester a jury during a high-profile case like this. My concern and why I filed the objection is just due to the duration of the trial. Having a jury sequestered for over 2 months, no contact with home, no contact with children, it's going to limit our jury pool. Our jury pool is going to consist of who? Retirees, no one with a job, and no one with a business to run. It's going to limit our ability to pick a fair and impartial jury that represents a cross-section of the community. So that's our concern. I share the concern with the state about publicity, about the jurers being hounded by the press. That's a legitimate concern. But I think that it's, with a 2-month trial, asking them to stay away from their home life for a 2-month period of time is burdensome on them. So we also agree this is a matter of discretion of the court, and I think the court had in mind the transfer of venue in anticipating that if it changed the trial location from Fremont County to Ada County, that the jurors would be able to go home and they would be able to carry on their life rather than put everything on hold for 2 months. And that's why we have respectfully objected to this motion. We do see the state's point of view, not ours. We'd rather have a jury that represents a cross-section of the